Constitutional protections for the accused, the one accused of a crime. So who, again, this is a recap, who does the Constitution protect? We've been saying individuals on U.S. soil, but that also applies to corporations and businesses as well. And who does it protect from? Well, the government, and government intrusion and government action against those individuals. The Bill of Rights, the first 10 amendments to the U.S. Constitution, that's where we find most of our protections that are afforded criminal defendants. And some of the arguments that were coming up in cases back then were the states saying, hey, those Bill of Rights that are in the U.S. Constitution, they don't apply to us. So it was after the Civil War, the 14th Amendment was passed, where 2 more protections were added to the 14th Amendment, due process and equal protection clauses. But also at that point is when the government made, in this amendment, those Bill of Rights applicable to the states. So it doesn't only apply to the federal government, those Bill of Rights and those protections. Under the 14th Amendment, it applies to states and local governments as well. So we are going to start talking about constitutional protections for the accused and going through the amendments. What does due process mean? What is the due process clause? What it says is no person shall be deprived of life, that's capital punishment, liberty, being incarcerated, or property, having the government take property through forfeiture or just taking it, without due process of law. And what we really mean about due process is fair treatment through the normal judicial system, meaning one can't be punished without proper notice and an opportunity to be heard, a right to a jury trial, the right to remain silent, the right to counsel, the right to be free from any unreasonable search and seizure, and a right to a speedy trial. So all of those things have got to happen within the judicial system in order for there not to be a claim that somebody's due process rights were violated. All of those protections are afforded. So that's the concept of due process. Under the 14th Amendment, we also find the Equal Protection Clause, which is different from due process. Due process, fair treatment within the judicial system. The Equal Protection Clause says, nor shall any state deny to any person within its jurisdiction the equal protection of the laws. The purpose of this amendment was to prevent states from enacting criminal laws that discriminated in an unreasonable and unjustified manner. These are laws that target a class of persons for special treatment. So laws that generally target a protected class or suspect class based on race, sex, national origin, disability, religion, sexual orientation. So an example that I'd like to use, like states could not pass a law that basically said it's illegal for women to wear bathing suits in public. That is clearly a law that targets a specific class of persons based on gender, and that would be deemed a violation of Equal Protection Clause. It's a law that targets a certain class of persons. So that's the Equal Protection Clause. Now we're moving into a very gray area of law, the Fourth Amendment, unreasonable search and seizure. This particular amendment can be an entire class in and of itself. You're just going to get a little snapshot of what it means and how it applies to business. The Fourth Amendment states, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describe the place to be secured and the persons or things to be seized. Generally, before law enforcement can search and seize private property, they must obtain a search warrant. Whether that property they want to search and seize is from a home, the person, it could be a briefcase, it could be a purse, a backpack, cars, sheds, warehouses, businesses, storage units, business documents, bank accounts, records, trash barrel, cell phones, computers, information on iPads, whatever that might be, law enforcement needs to get a search warrant before it can do so. The question is, what's a search warrant? Well, it's an order from a judge authorizing the search and seizure of private property. The warrant must specify what and who is being searched and what it is they're looking for and what it is that they can take, they being law enforcement. So, how does law enforcement get a search warrant? Well, they get it from a judge. There must be probable cause, some reasonable basis for believing that the search is going to reveal something illegal. But what does that really mean? They can't come in looking on a hunch. They can't say, hey, judge, I have a hunch. They need to actually have evidence that would convince a reasonable person that the search was more likely justified than not. And they have to come in and swear under oath that they have this kind of information or this kind of evidence that would convince that judge or reasonable person that a search is necessary and likely to turn up something illegal. What's important about the Fourth Amendment? Besides it's the Fourth Amendment, an unreasonable search and seizure is not something that us as individuals can be subjected to, but also businesses. Businesses and corporations have these same protections. The Fourth Amendment, however, applies to unreasonable searches and seizures. If it is a reasonable search, then no warrant is necessary. So there is a test. This amendment applies to a search if a person has a legitimate expectation of privacy. So if there is no expectation of privacy, then we're not going to have a violation of a Fourth Amendment right. Courts have generally applied a two-part test, which was established by the United States Supreme Court to determine whether at the time of the search a defendant had a legitimate expectation of privacy in the place or things being searched. So the questions that are asked are, first, did the person actually expect some degree of privacy? That's number one. If the answer is yes, then we move on to question two. Is the person's expectation objectively reasonable? That is it one society is willing to recognize or think is legit? So let me give you a couple examples. Let's say the FBI is investigating you and your business for tax evasion. If the FBI comes to your business location claiming they wish to review your accounting paperwork and they walk right in and they start going through files, do you have a constitutional violation there? Let's go through the questions. Did you expect some degree of privacy in your paperwork? The answer is yes. I hope you're nodding yes. It's your tax information. It's information that's personal to you and your business. So yeah, you did actually expect to have some degree of privacy in your docs. What about society? Would society recognize that expectation as reasonable? I would think so. So in that case, the FBI violated Fourth Amendment constitutional right to not be unreasonably searched and seized. But let's move on to a second example. Let's say the FBI is investigating you and your business for tax evasion. The FBI comes to your business location, enters the public reception area. There's a conference room that's kind of adjacent to the reception area, and the door to it is wide open. As the agent is waiting to be assisted, he notices the conference table is full of drugs and there's a handgun on the table. He or she enters and seizes the items. Do we have a constitutional violation here? And again, you got to go through the test. Did the person or you in this instance, actually expect some degree of privacy. Maybe it's your conference room in your business, but the door's wide open, right? We have the door that's kind of wide open and anyone can see right in there. So that while you may have had an expectation of some degree of privacy, the question is it one that society thinks is legit or will be recognized? And if we're looking at something that is like right there in plain view, the answer is there's going to be no. There's not going to be a violation in this instance. There are a number of exceptions to this rule of unreasonable search and seizure where there's a need for a warrant. That's the rule, you need a warrant. In these 4 instances, and there's many others, these are the most common ones, a warrant is not needed. Emergency and protection of society. And let's put this in a business context. If there is an existence of a general or neutral plan of regulation, let's say, for example, restaurants, they have to maintain permit. You have to maintain a permit under the health departments. So the health department is going to be able to come into that business and inspect it and not need a warrant, and they can seize anything, say spoiled food or contaminated food without having a warrant. So there's sometimes there's just a general neutral plan of regulation. There's no warrants necessary for highly regulated industries, strip mining, guns, businesses that sell guns, liquor is another area. It's for protection of society to be able to have those agencies or law enforcement come in when necessary. Consent. If somebody gives law enforcement consent to search, then there's no warrant needed and you can't argue about it later that there wasn't a warrant. Plain view, that was my example from last time. Anything that's in plain view. 4, hot pursuit. If law enforcement is pursuing a criminal, and that criminal, let's say, runs into their business or their house, they can pursue. So hot pursuit. A lot of businesses and corporations have personal security. The question becomes, does the 4th Amendment apply to private security? And the answer is no. So can private security search an individual? So let's take my example. Assume that a shopping mall security guard acting on a pure hunch searches a teenager's backpack. Inside the backpack, the guard finds a baggie containing illegal drugs. The guard can detain the teenager, call the police, and turn the drugs over to the police. Those drugs are admissible in evidence because the search here was conducted by private security guard acting on his own rather than at an officer's discretion. So, where we have private security, a search could be had even on a hunch. The question is, what if security is wrong about that hunch? What if they're wrong about the hunch? Is there any recourse? And the answer is yes. And that, what could happen? Vicarious liability. Back to the business. The business might be liable civilly, not necessarily criminally, but because of the conduct of the security guard searching somebody's bag, there could be some civil claim, and we'll talk more about that when we get into torts. So back to our law enforcement. What happens when a search violates the 4th Amendment? A law enforcement agent has been deemed to have conducted an unreasonable search and seizure. What happens? The exclusionary rule applies when a search violates the 4th Amendment. So if upon review a court finds that an unreasonable search occurred, any evidence seized as a result of it cannot be used as direct evidence against the defendant in a criminal prosecution. And a lot of law enforcement argue that this is unfair, since they've potentially had stopped criminal conduct. But it is what happens when there is an unreasonable search and seizure, that the evidence does not get used in a criminal prosecution. Sometimes that results in the case being dismissed, and unless the government does have additional information, are evidence, then a case can't go forward. This also applies to what we call the fruit of the poisonous tree. So this doctrine, not only is the evidence that is the product of an illegal search generally inadmissible in court, but so too is any additional evidence that derived from that initial evidence. We call it the fruit of the poisonous tree. The tree is the evidence that the police illegally seized in the first place, and the fruits are kind of the second generation product of that. So let's take an example. Officer Wiley arrests High-Low for selling phony telephone cards. A judge rules that officer illegally entered Lowe's home and improperly seized a map showing the location where Lowe hid the phone cards. Wiley then found the phone cards in that location because Officer Wiley obtained the map through an illegal search, and then it led them to the phone cards. Both the map and the phone cards are tossed out. They're not going to be used in the case. So inadmissible. Next up, we are going to talk about the right against self-incrimination.